A good time to break indeed for the defense, I think, because he was slow and methodical, but now there at the end, got the witness a little ruffled.
Yeah. I wonder if he could have pushed some more buttons there to keep him at that stage. I think it's good for both to get a break there.
Just take a break. Let's bring in our guest to discuss, see what he thinks about it. Joining us from Detroit, Michigan, national trial attorney Michael Jaafar. Michael, you've been a bit critical of this defendant representing himself. How do you think that moment played in court?
I think what I'm seeing is that the train wreck continues of a defense. You know, maybe I bring in my own bias into this case. I mean, everybody brings their own bias into these analyses. My bias comes from the defense, from a public defender standpoint, a defense attorney standpoint. The minute that he wrote a letter to the judge accusing the judge of being part of a criminal conspiracy to cover up the crime and put him in jail, to me, he just lost all credibility. Now, I'm not the jury. I'm not sitting in the courtroom. Maybe the jury didn't see that. I think they did. They were not supposed to see it. But I think that the train wreck continues. I mean, what I'm seeing here is what all his defense tactics are, which is just to ask a bunch of questions to try to make it. He comes into this defense assuming that everybody is lying and conspiring to put him in jail. That's what he comes into this with, right? And so all of his questioning is in that line. And I've been in at those defense tables where I'm forced to represent somebody because a judge forced me to represent that person. And I try to talk sense into that person and tell that person, we cannot go down this line of inquiry. It's only going to hurt your case. And I'm vetoed because I'm not the decision maker. I'm the attorney. The defendant is the decision maker, and the defendant has the right to do whatever he wants. In this case, this man has a national platform. He's going down every line of inquiry he wants, and his questionings belabor points that don't help him. Now, a broken clock is right twice a day. He's been right on a couple of things that he's tried to expose. But is he making any dent in getting an ultimate acquittal? I don't believe so.
Tough critic, Michael Jaafar.
I agree with Michael. He did. I'm listening to this guy. He's clunky. He's missing opportunities. He's frustrated at times with the process, which is totally understandable. And he gave up a deal for time served to roll the dice for this narcissistic exercise in front of everybody, with the stakes being so high. I think that this is a train wreck, and this is a winnable case. He's got a witness that was there, that was stabbed, who's going to say he didn't do it. And I think that any public defender could have done a better job.
And with the time served offer, and Michael Jaafar, if you can weigh in on this, only 7 witnesses so far from the state, and they offered him before he came to trial, yes, time served. What does that say about the state's belief in their own case?
Here's what I think, and again, this is my own conspiracy, but I'm pretty sure I'm right in this. The prosecution made the analysis that once he wrote that letter to the judge accusing him of being a part of a criminal mastermind and that he fired his attorneys, they knew about it because the attorneys had to call the prosecutor and tell him, hey, I got fired. And so the prosecution just kind of took their foot off the pedal and said, we're going to win this case going away. It's very, very easy. And so they kind of just mailed it in and didn't really put their full force into the case. This defendant reminds me of one specific defendant I had. I had a perfect trial record in defending people, and then I was forced to take a public defense of a person who was on video doing the crime that they accused him of doing. And his defense to me was, and he was really convinced that this was going to win him the cases, I don't do this for a living. I just did it this one time. So I tried to explain to him, well, but you're only being accused of this one time. You're not being accused. And, you know, and by the way, you do have a rap sheet. And so I have a deal lined up for you. We should take a deal. This is a case that should not go to trial. He just would not take the deal. He insisted on going forward. He insisted on testifying in his own trial. The judge wouldn't let me quit the case, and it was just an embarrassment. And so this guy reminds me of that exact person and that exact profile. And by the way, that happens across the board. You can ask any former public defender. They'll tell you the majority of my clients were just nuts and did not have the right frame of mind to put together a defense. So that's my opinion on why he didn't take a plea, and that's why I don't think he took a plea. I think he truly believes that he's going to win this case.
And walk out with his head held high.
mean, I think what you mentioned about that victim who is saying that he didn't do it, and you don't have the co-defendant, who's the main one in the stabbing, testifying. I think there's some holes, but I think a defense attorney could wrap this up nicely in a closing argument, so we'll have to see what he does with the closing argument.
Yeah.
We also want to bring in a criminal defense attorney, national trial attorney, Michael Jaafar, standing by. Michael, the nanny on the stand, this is a huge witness for the prosecution, not just because of what she saw, but I think it changes the tone there inside of the courtroom, because really what we've seen up until this point have been law enforcement witnesses. And now we're hearing from someone who has this personal connection to the victim. Talk about how important a witness like that is.
This witness is very important, very, very, very important. In my opinion, this might be the most important type of witness, because here's what I want to remind myself of when I read about this trial. This is still a very disorienting prosecution, because they have their hands tied, not their hands tied, they have a very difficult hill to climb, because they're trying to convict the girlfriend of the person having the affair of not only tampering with evidence, but with conspiracy to commit the original murder. That's going to be very difficult. That's going to be very difficult, because, you know, somebody could say, well, she had a motive. I don't think you have a motive to murder the estranged wife of a man you're already living with, right? She's already living with the woman. And I don't think it's ever rational to ever try to harm the person. I mean, if you're her when the estranged wife was still alive, you've won. He has 5 kids with her, but she left the house and he lives with you. So I just don't see the impetus to go that far. I mean, they lived in a mansion. They had it. They made it. They had the lifestyle. And you have to be a certain type of person to break up a family like that. And then you do all that, and then you conspire to kill the person, as opposed to just running the other direction when you find out that your new boyfriend wants to murder the mother of his 5 children. I just don't see it, right? It's going to be a lot easier for them to establish that she helped tamper with evidence, because pretty much anybody who's friends with somebody who's murdered somebody, I mean, I've never been in that situation, but I've defended people, right? Everybody's somewhat implicated in the after the fact type of effects of a crime, right? Pretty much everybody could be accused of tampering with evidence, right? Your best friend, and then you do something, and then your best friend finds out about it on TV, and then he calls you, is this right? Did this really happen? Well, this woman was living with the person, right? She saw him at press conferences. She saw him, when the car was found, hey, did you do this? I mean, of course she knew about it after the fact. Everybody who knew him knew about it after the fact. So that won't be hard to trip her into something like that. But to prove that she conspired before the fact to commit the murder, I don't know if this nanny or if anyone is going to be able to give convincing evidence that overwhelms the burden of proof. I'm still waiting to see that. I don't think that'll happen, but I do see juries being sympathetic to the victim and doing bizarre things.
Yeah, it's a tough case. This is a case where you look and clearly she would have been a great witness for them going after Fotis. He kills himself, and now it's like they need justice on some level, and they don't believe her. Those interviews are the reason she's sitting at the defendant's chair, because she changed her story, and so they think there's more to it. We'll see. Let's.